Thank you, sir. Sir, permit me to begin this debate today by stepping back for a moment from this particular cybercrime bill and the consequential amendments that are necessitated under the Mutual Assistance in Criminal Matters Act as it currently exists. Permit me to step back for a moment to have a conversation through you with all of Barbados about broader issues of cybersecurity and how we protect ourselves collectively from the very real and potentially debilitating threat of attacks on our data, attacks on our online activity, attacks on government, on businesses, and even the very equipment and systems that hold up our social and economic lives. So globally, we are, like everyone else, dealing with global issues of geopolitical instability, fast developing and emerging technology that we first need to understand, to adopt, if we so choose, and in ways that suit us. And then once we feel like we understand, we agree that they serve us in some way, that we wish to adopt them for the purposes that suit us, then to make those technologies secure for our use, and the data that they generate or they gather secure for our use. So we are similarly facing a skills shortage in this sector, and which I will come to in the course of this debate. And we are also facing rising shareholder demands, if you're a business, for security, and also rising regulatory demands that come rightly from the population and from businesses themselves. So in 2015, cybercrime damages were estimated to cost businesses and organizations $3 trillion in damage annually. That figure has now been increased to $10.5 trillion annually by 2025. So by 2025, it is estimated that cyber attacks and related incidents will cost us all $10.5 trillion annually. It is further estimated that 30% of the world's top 560 websites are not secure. 30% of the world's, I'm told, I'm advised by those who track such matters, 30% of the world's top 560 websites that people tend to use, so the most popular, are not secure. So web applications like calculators, sir, I am one of those people who likes to track calories and macronutrients and these kinds of things. I believe you all remember for St. Michael West and St. Michael South do similar things in their fitness pursuits. So online calculators, Google documents, email platforms, these things are all vulnerable to a variety of attack methods. So what kinds of things are these? We have things like SQL injections, and sir, you may notice that I'm taking well to the crash course that the others are engaging me in. So you have things like SQL injections where a hacker may use malicious code to get access to back-end data that was not intended to be displayed. So things like login boxes, the information that you enter when you log in, search fields, sign-up or registration fields, you enter that yourself. That is not meant to be publicly displayed, that is meant to go to a secure location, but there's certain injections of code that mean that somebody intercepts that information, and they're able to use it for their purposes. So they're similarly things like form jacking. So people put, again, malicious code into a web page, something like a payment page, where you might enter credit card data, and they access your financial information in that way. Sir, I will say here that I went online to make a payment recently for through a particular telecoms company, and lo and behold, the landing page, the payment page, had changed. It was a different URL, so it was a different address that you see in the bar. The address did not even bear the name of that telecom company. It was a whole different scene. And I stopped. I called somebody from the company, and I said, please confirm for me that you have changed your payment portal. Here is a photo of what it looks like on my computer. Can you please confirm that that is what the payment portal is supposed to look like? Because here it is, you've gone and changed the portal, everything we experience, the URL and everything that we see, and the people of Barbados, your customers, are simply supposed to believe that. I would caution any Barbadian, and I made a suggestion to the company, can you please put out a release that says our payment portal has changed, and this is what it now looks like. Sir, as I will come to later in my remarks, there are several places of intervention. There are several areas that are required to keep us safe in an online environment. State legislation, the matters that I will discuss in the Cybercrime Bill, or with respect to the Cybercrime Bill today, and other legislation that we have passed and will pass, that's just one part of it. A very key part of it is education by the private sector, of the private sector, by government, of citizens, to allow people to understand what is the kind of activity that will put you at risk, and what are some of the safeguards that we must all take. And sir, this Cybercrime Bill goes particularly to the heart of that matter, because I believe that information now is like air around us. And we get so used to receiving it and disseminating it, we often do not give a thought to how it affects us and how it affects other people. And in some cases, we give a thought, and we know that it will be damaging, and we proceed anyway. But sir, it is not just the legislation that we put in place. That is an important part of the cybersecurity framework. It is also some of the systems and the online tools that we procure and put in place across government and business. But it is also to make sure that users take the necessary precautions, because no amount of legislation is going to stop highly motivated individuals from trying to get access to your information. And so, yes, the legislation is important to send the right signals and to take the right steps, but I think that over the course of the coming months and years, we will equally be in a conversation through government and through the private sector to talk with consumers about the kinds of activities that are risky and how we can all protect ourselves. Sir, in addition to the kinds of hacking that I've just described, there are also what the experts will call brute force attacks. So really, all a hacker does is enter different permutations of possible passwords or codes until they find the right one. They just run some kind of program that will give them different permutations. They start entering passwords, entering passcodes, just different combinations. They don't have anything else to do. They do that all day and night. And they will run it until they hit the jackpot. And they find the passcode that will gain them access to this particular database or to your information. So in 2018, 48% of malicious email attachments were Microsoft Office files. I'm talking about, you know, the things that say .doc, .x, .dot, things that look normal. And someone sends an attachment. It's a Microsoft Office document. And we open it. 48% of malicious email attachments were Microsoft Office files in 2018. And so this is the environment in which we, against the background of all of the digital changes that are happening, this is the environment in which we must protect ourselves, in which the state must offer protection, in which the private sector, importantly, must offer protection, and is, as we speak, seeking the skills and the infrastructure needed so to do. This is the environment that we're dealing with. So in Barbados in 2022, the rate of internet penetration, internet connectivity, was 82%. In Barbados, a couple years ago, the rate of internet penetration was 82%. And that's one of the reasons that we can't sit back and decide that we will languish in this analog generation forever, because Barbadians expect to be able to use their internet access to expand their choices and live their lives well. Sir, at that time, there were over 235,000 internet users and 328,000 mobile connections. What does that say to you? That we are over 100% when it comes to mobile connection. People have more than one connection, people have more than one device, people are resolute in their need and in their interest in being connected to the global reality. And this is in a country with a population of 267,000. More and more Barbadians are choosing to live their lives online, socially, economically, and in every other way. And both government and the private sector must show up to give effect to those trends and those desires. I want to make it clear, sir, that the direction in which we are moving as a government, I dare say, is not dragging the population kicking and screaming. It is clear to us that people want to be facilitated in living their lives in a paperless environment, being able to have access to services without having to go and stand in lines. This is what people are asking for. Sir, and this approach simply makes people's lives easier. This approach holds tremendous potential for more people to work, to earn higher levels of income, and decrease the cost of doing business now and in the long run. So, sir, what have we been working on? What have we achieved, and where do we have to go with respect to this digital environment? So we've digitalized part of the immigration and border control process, including the welcome stamp application. Digitalized the application process for the police certificate of character and liquor license. And why those things? Why did we begin there? Because, sir, those things we found go to the heart of access to employment in the case of the police certificate of character, and in the case of the liquor license, goes to the heart of commerce in our culture and in our country. The BIMSafe and the SHAPE apps developed by Barbadians helped keep us safe during COVID. And so I believe they must be revisited for their potential in other aspects of healthcare management, or even in different applications and for different uses. We've expanded the services available on government's EasyPay Plus e-payment platform, undertaken the Smart Bridgetown project for free, full Wi-Fi coverage in the city. The Planning and Development Department, what we used to know as Town and Country Planning, now has an e-planning solution where applications are submitted and paid for online. And internally, are considered as well in an online environment in a situation where formerly things had to be sent back via courier. I have a file, and sir, the member for Christchurch West knows well, that some of these files, some of the documentation associated with planning applications, they're huge. They're plans, they're multiple documents, EIAs that are sometimes 200 pages long. Before, you would have to pick that up and carry that somewhere. And now through the e-planning, I believe they're in a second version to improve even the services that were originally offered. That is no longer necessary. And then we have the digital ID. But we have so much further to go to full operationalization of e-government with core services available online, to digital health and education access and products, to global monetization mechanisms for local online businesses with respect to products, services, and intellectual property. What do I mean by that? We have a bit of a gap in opportunity when it comes to how young Barbadians especially are able to monetize their products, services, and creations in an online environment. So we know that there's quite a bit of money to be made among people who, by virtue of their influence in a particular population, then attract advertising interests, are paid for those ads, and are able to generate income in that environment. And there's much more, much further to go in availing our young, and sometimes not so young people, of the opportunity to be a part of that global marketplace. And currently there are still some global financial and other challenges that prevent that. But we must be able to go further and to make those opportunities available to all. So for all of this, and importantly for the cybersecurity framework that must envelop all of this, we need to continue to invest in and scale up the cybersecurity and other tech training that we have already started. So we are right now underskilled in this area, and I know that that comment is going to spark a lot of representation that this number of people have graduated from UE with this particular certification and so on. That's not what I mean. We are right now underskilled in this area, in part because these fields are extremely dynamic. And we want to not just train young learners and transitioning professionals, but we want to have them work in diverse environments here and abroad, so that the risk environments that they experience and therefore respond to cover a universe of technologies and scenarios. So if you work in Barbados, and you know, remember for Christchurch, East Central, and I have this conversation all the time. Barbados has benefited from extremely sound economic governance for most of our lives, with a bit of a chasm in between, and then now again, since 2018. And we are grateful for that. We are grateful for that. But if you're an economist, excited to roll up your sleeves and do some work, well, I dare say Barbados is not the most challenging environment in which to do that. And why? The universe of problems that we have is very, very small. Some months ago, the member and I met at the time he was new, IMF representative for the area. He will more properly know how to call it at this time. These things have evaporated a little bit from my memory. But he is from Argentina. And as we were talking to him, there was a bit of jealousy in the conversation, because if you've worked as an economist in Argentina, then you have seen some things. I draw that parallel, sir, to say that when it comes to cybersecurity and other tech experience, those people who are coming through our systems, and they are talented. We, EBC, engaged the help of students from the Barbados Community College when the online transaction portal was giving some difficulty. And they stepped right up and they showed that they are able to operate in this space. But we want people to leave, work in multiple environments, understand what different types of risks look like, and then once they return, we have the benefit of that varied experience. So, sir, to be clear, our national cybersecurity strategy highlights several areas of simultaneous action that are required. And appropriate legislation is only one area of this action, and I will come to some of the others during the course of my remarks. So, sir, in the area of legislation, we know that the Electronic Transactions Act will likely need to be amended to facilitate some of what is contemplated as part of the digital ID and other parts of the national digital strategy. And so these are efforts that we will have to revisit and undertake. And the national cybersecurity strategy, which I encourage Barbadians to have a look at, lays out some of what is required. Sir, I do want to say about that strategy that it is exactly, to my mind, what a strategy should be. It plainly lays out what the gaps are, it indicates what is being done, and it, at the high level, says what must happen in order to get us where we need to go. And that is really to give us a snapshot of what needs to be done. But we need to work through and work plan all of these items in order to come with something that we can execute. So we have the Electronic Transactions Act that exists, but that will likely require some revisiting. In 2019, we passed the Data Protection Act, and we've also appointed a Data Protection Commissioner. Sir, I believe that perhaps some of what is contained in that act and some of what it affords Barbadians in the way of protection is not clearly understood. And I am one of those people who believes that if somebody doesn't understand me, it means that I did not communicate well. So I'm not saying that it is the public's deficiency not to understand, but I'm saying that it is worthwhile to be able to keep talking about that, because I think sometimes some of the consternation and the anguish and the anxiety comes from the notion that people's information is not protected when we clearly have a piece of legislation that speaks to how that protection functions and that empowers a data commissioner, a regulator. The Office of the Data Protection Commissioner is a regulatory function to be able to do that work. Now, we've just come through estimates, and I feel very strongly that an Office of a Data Protection Commissioner requires more than one commissioner and two administrative people in order to function. If you consult the Data Protection Act and you look at the range of functions for which she is responsible, you'll understand that the office needs to be resourced, and I consider that I'm standing in the right position in this chamber, next to the member for Christchurch East Central, to impress on anyone who may need to know that these are resources that are required in order to give effect to what we are trying to do here. So, sir, the Electronic Transactions Act, the Data Protection Act, and the appointment of a Data Protection Commissioner, and then there is a Computer Misuse Act. And that act, sir, is our point of departure today. The Computer Misuse Act, Cap 124B, came into force on the 18th of July, 2005. And that act sought to make provisions for the protection of computer systems and the information contained in those systems from unauthorized access, to protect them from abuse by persons authorized to have access, and related matters. Now, sir, we have also taken the step of establishing a law reform commission. And the importance of that commission, not just in this work, but in all areas of legislative function and the process of determining necessary regulation, determining whether the legislation that currently exists suits our purposes today and going forward, I don't think we can understate the importance of that Law Reform Commission, and I thank them here now for their tremendous work. I will return at the end of my presentation to thank them again, because, you know, to be able to assess the lay of the land, to say what does not work, to be able to source the right support to make these legislative changes, this is no small thing. And so the Computer Misuse Act came to the attention of the Law Reform Commission, and I would say for a number of reasons. And I want us to have a common understanding of the domestic reality, but also of the regional and international reality. Sir, we have all heard of the various cyber attacks of government agencies and of businesses. I don't need to revisit those in this chamber today, but there is understandable fear when financial institutions, when government institutions responsible for data, when these are the subject of orchestrated attacks. Now, it is one thing to, and it's bad enough, to have a situation where information is made insecure because it is left somewhere or because it is inadvertently sent somewhere. It sparks a different level of trepidation, a feeling of being targeted, when you are the subject of a legitimate, targeted cyber attack. And we have had, in recent years, some examples of this. And there is a need to respond. But there is something else that necessitates this conversation here today. And that is what one might consider the indiscriminate use of personal information for the purposes of taking advantage of an individual, or for the purposes of harassing or bullying an individual, or for the purpose of having some financial or other benefit from a person's private information. Sir, I feel as if we have regrettably come to a point where there is scant respect for information. And I say we, meaning all of us. Because I get something on my phone does not mean that it passes the test of that which should be transferred, or that which should be shared with a third party, or that which should be the subject of wide discussion. I fear that because information is so accessible, we almost feel like hitting send absolves us of any responsibility. Well, I didn't write it, I didn't create it. It's almost like when you go in a store and buy something and it malfunctions and you take it back and the person says, well, I didn't make it. You have a responsibility for your role in that chain that has caused me to be affected by the transmission of that information. Sir, the Computer Misuse Act started to go some ways to address these issues that affect us locally. But to the extent that addressing cybercrime calls for a legislative response to the newest in technology and technological approaches, to the extent that it must allow for international cooperation in matters where physical borders don't exist, they don't matter. Based on this, it's been adjudged by the Law Reform Commission that the Computer Misuse Act is woefully inadequate for 2024 and beyond. And so it is on this basis that the Commission accepted the offer of assistance from the Convention of Cybercrime of the Council of Europe, known as the Budapest Convention, which is the only binding international instrument relating to cybercrime, and which serves her as a guideline for any country that is developing comprehensive national legislation against cybercrime as a framework for international cooperation between state parties to this treaty. In other words, sir, these matters don't just require action at the domestic level, and they don't just affect us. In fact, in many cases, they do not originate domestically. They originate in many parts of the world and require the capacity to investigate, to operate jurisdictionally in other places. And so the Law Reform Commission thought then that it would be an appropriate time, given the offer of support, to compare the existing act with the requirements necessary to meet this convention. Now, I want to make it clear that the process was as follows. We determined locally that we were dealing with some challenges with respect to cybersecurity and cybercrime that we needed to address. The Budapest Convention is the global standard for how countries address this, not just because someone has said so, but because it actually provides a framework for how, as countries, we cooperate to bring effect to these issues. So the Council volunteered assistance to the Commission to look at what were the deficiencies in the Act and to facilitate the drafting of a piece of legislation that was more contemporary, more modern, and would suit our purposes better. And so we had virtual workshops with representatives of the Commission, 2 draftspeople from the Office of the Chief Parliamentary Counsel were involved, and that was back in 2021. The Act was reviewed, a draft bill was prepared, and then we had a final meeting with the representatives at the end of 2021, and then further work last year in 2023, September, when the Council of Europe sponsored 3 workshops for judicial officers, police officers, prosecutors, service providers. The proposed bills, and sorry, take the time to go through these details because it is important to make clear that in this matter, as in all matters, we took the time to speak to experts globally, regionally, and locally. We took the time to consult with people who will have to enforce. We took the time to consult with people who will themselves be monitoring systems for cyber attacks. We took the time to consult with people in the private sector who offer such services internationally as well. and who were able to give their perspectives on what was being proposed. And so subsequent to the workshop, once these matters had been reviewed, the Chief Parliamentary Counsel's Department made some minor adjustments, and we find ourselves here today with the bill that is being proposed. So, sir, the Cybercrime Bill 2024 provides for the combating of cybercrime, the protection of legitimate interests in the use and development of information technologies, and I pause on that particular provision because I want to emphasize, and I will later in my presentation, that this cybercrime bill is meant to create offenses in cases where there is true criminal activity that is intended and taking place, but it is also designed to protect legitimate interests and development. It is not designed, and it is particular in its framing, not to criminalize or penalize those experts, those professionals, those service providers who are in the business of surveillance, of ethical hacking, by which I mean they try to break a system to see whether it will break. The bill, not in its intent, nor in its design, nor in its presentation, the bill does not penalize those groups of people. So combat cybercrime, protect legitimate interests in the use and development of information technologies, facilitation of international cooperation in computer-related crimes and related matters, and it would therefore repeal the Computer Misuse Act, Cap 124B. So, sir, just to quickly address what the bill is aiming to do in its clauses, and to summarize. Part 2 of the bill looks at prohibited conduct, and I will go into some of these more fully, but really just to summarize. What is the prohibited conduct under the bill? It speaks to issues of illegal access to information, to systems, modifying or interfering with program or data. This is prohibited conduct. Interfering with computer system, and I will go into details of the conditions under which those are considered unlawful or prohibited. Illegally intercepting data that you are unauthorized to intercept. The misuse of devices. Access with intent to commit a further criminal offense. Disclosure of access codes. The question of the treatment of critical information infrastructure systems is also addressed under the bill. The conditions under which one receives or gives access to computer programs or to data. The bill also outlines the prohibited conduct with respect to computer-related forgery, computer-related fraud, child pornography, child grooming, online sexual abuse of children, malicious communication, cyberbullying, cyberterrorism, and the question of aiding and abetting these acts. Part 3 looks at investigation and enforcement. So what is involved in search and seizure of data and systems and programs, the conditions under which a police officer may be assisted in her or his duties, the record of seized data and the conditions under which it is to be provided to the owner, the production of data for criminal proceedings, and expedited preservation and partial disclosure of traffic data. Part 3 further looks at the preservation of data for criminal proceedings, looks at how orders are made for the payment of compensation, and then goes into any necessary regulations and consequential amendments, and so on. So, sir, I will not seek to be exhaustive in going through the clauses, because I think much of what the bill outlines is well explained in its presentation. And so I endeavor, sir, to have a bit of a conversation through you on some specific explanations. And sir, I really beg the indulgence of the chamber because I also have to go further. I believe that when citizens, anyone makes representation to the government in terms of concerns that they have with respect to a particular area like cybersecurity, that we have a responsibility to answer. And so, in the course of my discussion, sir, I also propose to answer some of the concerns that have been raised. Sir, this is part of the conversation, the conversational approach that I'm hoping to encourage as we go forward. Sir, I will also say before I proceed that we are discussing at the same time the Mutual Assistance in Criminal Matters Amendment Bill, because when that act was first contemplated, first passed and proclaimed, one could not have known that we would have such complex matters of computer misuse to confront. And so the consequential amendments that are outlined herein are really as a result of having to bring effect to the Cybercrime Bill, and really adding information and making provision for that same mutual assistance that countries would have, those partnerships that countries would engage in, to extend that beyond the kinds of crimes that we are traditionally aware of and exposed to, and expand that to the cybercrime that is covered in the bill. So, sir, this bill makes it an offense to intentionally or recklessly and without authority gain access to the whole or any part of a computer system, cause a program to be executed, or use the program to gain access to any data without authority. And it is important to understand that in many frameworks in which we work, in which we carry on our personal lives and our personal commitments and our social expressions, that there's an issue of access. To get into a building, you're given an access card. If you don't have that card, if you don't have a key, if you don't have the means of entrance, if you have not been equipped with the wherewithal to gain access, it means you have to ask for permission. I think that is a general understanding that we have. If you determine that you would rather not ask for permission, and you gain access anyway, then that is without authority. Similarly, if there is a device, a tablet, a computer, a data center, a program, a piece of software, something that you are aware, either by virtue of you not having a password, you not having a key, you know you don't belong in there. So I think that it is, the Cybercrime, the Computer Misuse Act had made reference to without lawful excuse or justification, and it was considered that that was quite a broad and undefined term. And so we opted then to stipulate without authority, considering that this was far less defensible and gave far fewer options for people to say, well, I had an excuse or I had a justification, as they might have done under the former act. Sir, the bill also makes it an offense to illegally, at clause 8, to illegally intercept data as it relates to non-public transmission to, from, or within a computer system. So, sir, those practices that I mentioned, where you intercept somebody, a payment portal, you create malicious code so that when somebody is entering their credit card information, it actually comes to you and doesn't go to the intended recipient. Those kinds of offenses are prohibited conduct under the Cybercrime Bill. It further makes it an offense, sir, to intentionally, recklessly, or without authority produce, sell, procure for use, import, export, distribute, or otherwise make available a device primarily designed or adapted to commit an offense. So a device that has been built, procured, primarily to commit a crime. To procure that, to produce it, to sell it, to import it, to export it is an offense under this legislation. Similarly, it is an offense to produce, sell, procure, etc., a computer password, access code, or similar data. So I may not use the password myself. I may not use the information myself. I may sell lists of credit card information, has been done to people so that they can carry out the malicious proceedings that they intend to carry out, sir, with your credit card information. Now, I think it's important to pause and indicate that the former act, the Computer Misuse Act, also criminalized that activity. It didn't criminalize the production and procurement for use of devices or computer passwords. So there had, maybe a decade ago, there was a raging debate about this issue of the data that companies collect about you and how it is permitted to be used. And I remember that I was living abroad at the time when the country where I was living determined that a company couldn't call you if they had gotten your phone number from a source other than your provision of your contact information to that company. And so for example, there was new legislation that gave this opt-in or opt-out provision because they determined that if a company got your information by means other than your express permission, they could not benefit. They could not potentially benefit from using that information to advertise their product or service. So there are far-reaching implications, and there are potentially far-reaching applications, sir, of this kind of approach. Sir, clause 11 makes it an offense intentionally, recklessly, or without authority to disclose access codes. And I think the qualifications here are important, and I'll come to that when I respond to some of the comments that were given by others. So the disclosure of access codes. Clause 14 introduces the offense of computer-related forgery. So then it is an offense to intentionally and without authority input, alter, delete, or suppress a program or data that results in inauthentic data being considered or acted upon for legal purposes as if it were authentic. So, sir, our traditional idea of forgery is that I have a look at the signature of the member for Christchurch East Central, and I practice a little bit with my hand. And if I want to represent his person or his authority in some other environment, then I reproduce that with my hand. And I say, the member for Christchurch East Central signed that. Here it is. But there is forgery possible in an online environment where I interfere with how a system functions, where I interfere with data, where I misrepresent a digital signature or other representation of a person or of a company or of a program. And that is also an offense. Sir, I want to come now to some of the issues that affect Barbadians, perhaps in a more fundamental way. And so clauses 16 to 20 address issues of child pornography, child grooming, sexual abuse of children, malicious communication that is meant to harass, and cyberbullying. And I think this is a very important provision. These are very important provisions of this legislation. Sir, the Child Justice Bill and its accompanying legislation, the Child Protection Bill, have for some time been before the select committees for consideration, and I know have benefited from rigorous conversation. In everything that we do, in every environment in which children may be taken advantage of, we have a responsibility to protect them. This legislation, sir, makes it an offense for an individual or a corporation to intentionally or recklessly publish child pornography, so videos, photos through a computer system, produce child pornography for the purpose of its publication through a computer system, possess child pornography in a computer system or on a computer data storage medium for the purpose of publication, or procure child pornography through a computer system for himself or for another person. Sir, you know, there are representations, there are manifestations of ways that we choose to represent ourselves or our family members, or activities in which we might engage, in which we should not. Because while you may be thinking, or while you may believe that this photo or this video, you didn't produce it, you didn't take it, but if it represents, if it has the potential, if by its dissemination, if by its consumption, even on a single device, to represent harm to a child, which such images do, then it is and must be unlawful. Sir, the issue of sexual abuse of children, with which we continue to struggle, does not or need not originate at the beginning of the physical act. There is intent, there are preliminary actions, there are things that foment certain kinds of behavior that must equally be considered and be declared abhorrent and not tolerated by our society. The notion that something is just a picture, when in circumstances where that image is used to abuse the psyche of a minor person, it is not just a picture. And so this legislation makes reference to the dissemination of pornographic material with respect to children, but also of what we consider child grooming, making contact with and engaging a minor for the purpose or for furtherance of an illegal sexual act. And it further criminalizes any online activity with a child that is in itself of a sexual nature. So, a WhatsApp video call, a conversation, a text conversation, any engagement that a person has with a minor for the purposes of setting up a meeting, for the purposes of finding out where to live and going to collect them, those activities are criminalized under this act. So I will tell you that some of these conversations are difficult. And they're difficult because some of us have been witness to some very flippant approaches to how people treat children or how people sexualize children. This debate, sir, is not about child abuse. But I pause here for the amount of time that I have because I want us to understand that it is our duty to protect children everywhere. And this sometimes early sexualization of young people gives rise to other kinds of acts. And I am happy that this legislation not only criminalizes such behavior, but that the fines associated with such behavior, standing as they do at 100,000 versus the 70,000 or 7 years that are associated with most of the other offenses, those fines go further because they send the message to those who would offend that we are serious about protecting children. Sir, let me come quickly to another challenge that we have, to which we perhaps take quite a cavalier approach. Clause 19 creates an offense where a person uses a computer system to disseminate words or images, not caring whether they are true or false, and cause a person embarrassment, ridicule, or contempt. and anything that we would consider defamation in other areas of the law, those things are applicable to this clause. This is at 3 of clause 19. At 2 at clause 19, it deals with the offense of what we have commonly come to understand as revenge porn. So, I have in my possession, and I can't use any member here as an example because I don't want that enhancered. I have in my possession a sexual or sexualized image of someone that I know, someone with whom I was in a relationship. That person may have shared that with me because they wanted me to have it. I'm not in the practice of such things, but I understand that some people, and with an expectation of privacy, And perhaps it causes us to pause and reconsider what is a reasonable expectation of privacy. Because as much as we would want relationships to last forever, many do not. And even if they last, we have now given the power to another person to affect our lives and our chances in life, our well-being, whether we go to apply for a job, what people associate with us online. We have given that power to that person. So perhaps we must revisit the extent to which we want to deliver or to give that power, to send those kinds of images of our person. But in a situation where that has been done, and you expect that you have confidentially transmitted this image or video or whatever it is to a person known to you, and then that person decides, you know what? You see, I barely care about he in the morning. Not very parliamentary language, but I'm trying to explain the circumstances under which these things happen. That person determines that they feel they have been wronged, and they consider that those images that you have shared with them are their leverage for causing you harm. Clause 19 at 2 makes it an offense for that individual to transmit those images for the purpose of causing you harm, harassment, defamation. Those issues are addressed under this clause. But I want to make a final point on this issue of personal relationships and what is accepted or not accepted. We sometimes have a very cavalier approach to other people's devices and other people's information if we determine that that person's cohabitation with us or that person's status in a relationship with us give us certain entitlements. I want to caution, not just for the purposes of this legislation, but in general, that that person's information is their own. And you are only entitled to it to the extent that they surrender it to you. And so, the idea that you see a phone sitting there, and you see a name, and you're unsure who is that, and you wonder, what cause does a person who is unknown to you have to be making contact with this person with whom you are in a relationship or in some kind of association, and determine that you are justified in gaining access to a device in order to satisfy yourself of certain things. I've seen in jurisdictions recently where people have been successfully prosecuted for gaining access to a device in order to prove infidelity, in order to prove financial misappropriation, if you brought into somebody's house to prove that they were engaging in acts not authorized by you or not condoned by you, because you can't authorize them, you would be charged for breaking and entering. Your motivation in the collection of evidence does not justify you in unlawfully gaining access to that home, to that phone, to that computer. Even outside of the confines of this legislation, I generally prefer to caution people not to do it. And further, I feel like if I am meant to find out something, I can find out. I can find out. And even if I don't, the kind of anxiety that is associated with this constant collection of evidence, it can be good for the Constitution. That is more personal advice than anything. Sir, Clause 21 creates the offense of cyberterrorism. And Clause 22 introduces the offense that the Computer Misuse Act did not cover, which is the offense of aiding or abetting these kinds of activities. Sir, I have been on my feet for some time, and before I take my seat and allow others to enter the debate, I do want to turn now to some of the feedback that we've gotten. And I will be very specific and deliberate in this regard, because I will say this. I believe that this government has had a spirit and a practice of consultation. I feel as if this administration must be one of the most consultative in the world. Standing committees of the House, joint select committees with respect to particular legislation, town hall meetings annually by parish, town hall meetings by subject. The member for St. Michael West Central was just engaged in some with respect to tourism accommodation and so on. Constantly availing ourselves of the benefit, because I don't consider it a favor to the population, it is to help us serve the population better. And so, sir, this cybercrime bill was no different. It enjoyed the consultation, the review of those within and outside of government, those who are responsible for enforcement, those who are responsible for surveillance and experts in cybersecurity. And we considered that consultation pathway remains open. We don't put out anybody and say, thanks, good night, we've had enough. If there are cases where we believe, a person believes that some things must be an ongoing conversation, we welcome the ongoing conversation. And so I say that to reinforce that we do not consider that it is necessary in these matters where consultative partnerships have been established to feel like the door is closed. Notwithstanding, sometimes people feel that they may not have had an appropriate first hearing or the first hearing that they expected. And so we've gotten some specific response from some who voiced some concerns. And so, for example, I will try to go through them very quickly, because I do think it is our duty to respond. And to respond in the full context, in public, where people can hear and understand that this is our intent. So, With respect to Clause 4 says that a person who intentionally or recklessly and without authority gains access to the whole or part of a computer, causes a program to be executed, uses a program to gain access to any data, is guilty of an offense and liable on conviction of indictment to a fine of $50,000, imprisonment of 5 years, or both. So the feedback we received was that this is too broad in its scope, and that this might implicate innocent or well-meaning individuals. Sir, we consider that Clause 4 is actually consistent with international best practice provisions in the language and in the intent. It criminalizes illegal access to a computer system or computer data where it is committed without authority. So this is well-established cybercrime practice. The language is consistent with international best practice provisions that criminalize illegal access. So it cannot implicate innocent individuals, because what has to be proven is that this access was without authority. And in most cases, I would judge that it is quite simple to establish the absence or presence of authority. So the actions of cybersecurity professionals will not be criminalized, since those professionals are acting with authority. Reporting by journalists or whistleblowers once it is lawful will not be criminalized. But if that journalist or whistleblower gains access to a computer system without authority, that will be criminalized. And, when we spoke of the clauses 20, the clauses dealing with cyberbullying and harassment, sir, there's language that talks about disseminating information without regard to whether it is true. And I feel like that is not just admirable or appropriate language in the legislation. I feel it is an appropriate lesson for all of us. Because we receive something on a phone, we hear somebody whisper something, and we believe that we can just continue to replicate information that we do not know to be true. We have not checked. It is not in evidence that we can be objectively verified. Someone has said it, and we choose to share it. You see on your WhatsApp forwarded many times. A person decides, without regard to how it will affect the member for St. Thomas, the member for St. Michael West, they do not care. As far as they're concerned, I got it on my phone. And you will hear that often in the hallways. You heard about so-and-so? I got it on my phone. I can send you. What's the language? Without regard for whether it is true. And it is time that people are accountable for their role in originating that information without evidence and then disseminating that information. It is no laughing matter. People have their professional lives. People have their families. People have to walk the streets of this country with their heads held high in cases where they have done nothing. And it is no small thing. You cannot just start rumors, perpetuate rumors with malicious intent and not be accountable. And so, the mutual assistance component of this means that where people do this, generate information that they have not checked, that in many cases they know to either be false or unverified, they sit in an apartment in New York City or in Brooklyn, in Jamaica, in London, in Manchester, and believe that because the Barbados Police Service has no jurisdiction there, that they can get away with it. Well, no longer under this legislation. Sir, we similarly received some feedback on the question of illegal devices, and it was suggested that where Clause 9 makes reference to a person who intentionally or recklessly and without authority produces, sells, procures devices for the purpose, primarily designed for the purpose of committing an offense. This commentator suggests that there are a number of dual-use programs and applications which can be used for legitimate testing and similarly for hacking that would cause harm. And we make clear that the devices covered under Section 9 are devices that are primarily designed or adapted for the purpose of committing an offense. So it necessarily excludes devices that have a legitimate primary purpose, such as the dual-use devices that are mentioned by this individual. So any activity such as ethical hacking, which is conducted with authority, would not be covered as unlawful or what would not be considered an offense under Section 9. Similarly, disclosure of access codes that is referenced at Clause 11. This commentator considers that there are several legitimate reasons for sharing access codes. Again, it is difficult for us to consider a circumstance in which you would permit the disclosure of access codes without authority. In every case, authority is the determining factor here. And so, yes, if I share my password with a member for Christchurch East Central, and he gains access to my device, then he has authority. And the matter would not be considered unlawful under the Act. Clause 12 that relates to critical information infrastructure systems, and it defines a computer system or defines this as a computer system or a part of a computer system, whether physical or virtual, a program or data containing information that is vital to the security, defense, and international relations of Barbados, the provisions of service directly related to communications, banking, and finance, the protection of public health and safety. So those are all categorized as critical information infrastructure systems. A person who, without authority, gains access to those systems is liable on conviction or indictment to a fine of $100,000 or to a term of confinement, etc. Again, the commentator considers that the list of critical information infrastructure is too limited in scope and a broader list should be published. However, our response to that would be that it is not advisable to require the establishment of an exhaustive and complete list that is designated as critical infrastructure, because the things that are considered critical may change from time to time. So it would make it impractical for us to identify all and itemize all of the things, the various devices, the locations, the systems that would comprise critical infrastructure. It is not a viable suggestion. And it is our consideration that the definitions that are established herein mean that whenever there are changes in what is designated critical infrastructure, that we can respond. There have been, and I should say that these comments are originated from one individual, so I don't want to give the impression that these are multiple concerns. There have been concerns about the notion that the cyberterrorism definition is too limited in scope, but the terrorism is already defined under Section 22 of the Anti-Terrorism Act. And so the Cybercrime Bill draws on the definitions of terrorism as outlined there. With respect to search and seizure, Clause 23 makes provision that where a magistrate is satisfied on information on oath given by a police officer that there are reasonable grounds for suspecting that an offence has been, is being, or is about to be committed, the magistrate may issue a warrant authorizing any police officer to enter and search that place, including any computer system, using such reasonable force as is necessary. The commenter feels that this gives law enforcement excessively broad powers when it comes to confiscation and access to computer systems. However, this legislation, like all other legislation, provides independent oversight as it requires the police to obtain a warrant from a magistrate based on specified grounds. So the same way that you would need to obtain a warrant to gain access to a physical place, you similarly must obtain a warrant from a magistrate based on specified grounds, and the magistrate has discretion in terms of which specific powers will be granted to search a place. It does not mean that the police authority does not have to act in a correct manner to gain access to a person's property. It does not remove that requirement. But it is not new or different to the extent that it makes use of the standing system and the requirement to obtain a warrant as it would in any other criminal matter. And finally, the question of production of data for criminal proceedings. Again, the complaint is the same, that it gives, Clause 26 gives law enforcement excessively broad power and intrusive surveillance powers when it comes to intercepting internet communications. I want to make clear that this power is limited in the legislation to seeking production of specified computer data. That is how it is framed and exists under the Budapest Convention that most other countries follow. This provision does not enable surveillance or interception of communications. It is limited to stored computer data and to subscriber information. So I think perhaps the commenter misunderstands the provisions because it does not enable surveillance and interception of communication. It in fact enables only specified computer data that is stored in cases where a judge or a magistrate is satisfied that based on the application of by a police officer, that data is required for the purpose of a criminal proceeding or a criminal investigation. Sir, I turn now to my final area of conversation or explanation. I consider that there will be future occasions to go more in depth into the cybersecurity strategy. This cybercrime legislation does not and cannot cover all areas of cybersecurity strategy. There are resources that have to be brought to bear that, for example, will allow for certain forensic tools to be used, that would allow for certain cybersecurity-related hygiene that has to be carried out, that would allow for response teams, that would make provision for reporting of cybersecurity incidents and make those mandatory within certain government frameworks. There are options, sir, that we continue to explore as part of the cybersecurity strategy to also give citizens the wherewithal to see who has accessed their data and for what purpose. There are countries, I believe Estonia is one, where citizens are able to, or perhaps not Estonia, but where citizens are able to see where some of their information as stored by government has been accessed and for what purpose. I say these things to say, sir, and of course we have to invest in having cybersecurity resources, professionals, people who are engaged to make sure that each area of information where it exists, to make sure our data centers are secure. These are all parts of the strategy. In no wise am I suggesting that a cybercrime bill ticks all the boxes, and it is only one part of what our efforts will need to be, along with education of the public, because there are some things that we all do that we should not be doing if we are serious about securing ourselves in an online environment. And we will, in coming weeks and months, engage the public fully on some of those others, cybersecurity efforts. But I want to come finally, sir, to the last set of concerns that have been circulating, and I thank the individuals who met last Friday, who earnestly and in good faith discussed their concerns. And I just want to briefly respond to some of them. Some of the concerns that were communicated by citizens of Barbados, the document frames the group as citizens of Barbados asking government pertinent questions about the Trident ID and Barbados Identity Management Bill. The document was drafted on the 26th of January this year. So I consider that some of the concerns that have to do with rights and access to goods and services are addressed by the information that I shared earlier in my ministerial statement, which removed the deadline, and in so doing removed any requirement to have the digital ID in order to access those goods and services. So I think that much of what has been outlined as a concern, that provision removes that, and I reiterate that the BIM Act, Barbados Identity Management Act, will need to be amended, but we will be careful and intentional with those amendments to give effect to the intent, but that administratively, in terms of policy and practice, that is how we go forward from here. But I wanted to come to a concern of the group that has to do with the information that is collected by the Electoral and Boundaries Commission and the extent to which it is vulnerable, or it might be vulnerable, to be disseminated in ways that are not authorized. First, let me clarify the information that is associated with the card. There is a set of information that is available visually on the face of the card. Your national ID number is available visually on the face of the card. Document number. Your names, given names and surname. The date of expiry of the card. Sex. A standard 2D photo. Your nationality, date of birth. Whether you are a senior. Whether you are a person with a disability. There's a QR code that when it's scanned shows your driver's license information. It shows the driver's license information that is available on the face of your driver's license. And there's a QR code that on a minor's card, when it is scanned, it shows the minor's guardians, primary and secondary. So that's available on the face of the card. And that is very much in keeping with what has always been available on the face of the card. The only new information collected in this registration has been disability category once volunteered. It is voluntary to submit that information. A secondary guardian before minor cards. For minor cards, the only information that was collected was a primary guardian. But from a position of protection of children, it is important to be able to have access to who might be a secondary guardian in cases where this information needs to be made known. And then the permission to place the word disability on the card. That is the only other thing that is new. Secondary guardian for minors, the category of disability when people opt to give it, and then the permission to place the word disability on the card when people opt to have that on their card. There are many Barbadians living with disabilities who want people to have that information up front because it relieves them of certain conversations and justifications that are very uncomfortable and difficult and, quite frankly, unnecessary. So that is the only new information collected as part of this new registration process. Everything else available visually on the face of the card was always available visually except for what are called MRZ lines, so that set of code that you see at the bottom. The information that is protected by your PIN. Now, the question was asked by the group, is pinning of the card mandatory? I think I have satisfied most Barbadians that nothing from here is considered mandatory. But the pin and the chip technology is what makes the card digital. If you don't have the capacity to have information that is securely stored and made available to certain institutions with your authorization, that is your PIN. And the Cybercrime Bill, once passed, will now make it an offense for people to illegally access your PIN. So unless you give your PIN to someone, a person cannot legally access any information that is what we call behind the PIN. Because it is your PIN. It is like having a credit card, an ATM card. You use it yourself. You have to pin it. So, and you have to choose to go in and choose a PIN and pin the card. So, it is not mandatory, but if you want to transition the card from just, again, being a prettier version of the plastic ID card, if you want to transition the card in terms of functionality from there to being able to be used in different environments, and I'll revisit in a second what those are, then you may choose to pin the card. The technology that the EBC is now working on, in the case of seniors and being able to ride free of charge on the transport board buses, requires, unless it will be a contactless technology, it requires the PIN to be used. I say requires because this is a benefit. To be able to securely, let me put it another way, to verify that it is you riding free of cost. Only one person presents with that set of attributes associated with that PIN. And so it is a way for you to have comfort. You know, we have all kinds of cases. Less so, obviously, in the case of transportation. More so in the case of pension checks. Getting access to people's pension. It is in the interest of an individual to be able to prove that it is you or that you are unequivocally authorizing a third party to carry out a transaction on your behalf. It is in the interest of the user. That security protects the consumer. And so the information that is PIN protected, place of birth, as in country, that is what we call behind the PIN. So you enter the PIN, you see that information, or the person that you are giving the card to and entering the PIN in front of sees that information. Date of issue of card credential, marital status, height, address, parish. You have the option, sir, to share your home phone number, your mobile number, your email address. You have the option. And disability category. So, sir, you will hear from that explanation. And then, of course, there's the information on the driver's license, which is shown when the QR code is scanned, which is, if you look at your driver's license, which is also on the driver's license. I say that to emphasize, sir, that the information fields that I've just outlined can hardly be considered sensitive information to the extent that they're either already on the face of your ID card, to the extent that they are, in the second case, behind your PIN, so they're accessible when the PIN is entered. And sir, I am not at all trying to be facetious. I take these comments in good faith. But your name and address and phone number are in the phone book. They're in the directory. And so I think part of the conversation that we want to have is what is the information that we are comfortable sharing? Because I want us to understand that, you know, I have an allergy. I'm not going to say what I'm allergic to, because that might invite another kind of hacking, biohacking. But I have an allergy, and when I was younger, at university abroad, I was made to wear a bracelet. And the bracelet contained information about the allergy. I said made to wear because it wasn't mandatory, but it was an option in the event that I have a reaction in which I can't communicate, and the officers responding will use their device and read the bracelet and have the information. Sir, the only specific information, the information that I've just given you is what sits on all cards, and only that. That information in different environments, like the polyclinic, the licensing authority, the University of the West Indies, if those services are onboarded, whatever services are onboarded, those original credentials are all that exist. They are then used for the institution in whose device you are entering your PIN to then use that to access administrative information that they have in their records. The card itself does not carry that information. It is only when you authorize the access that the Queen Elizabeth Hospital, for example, should we move to that functionality, will then say, oh, I am sure that this is George Brown. I have proof of George Brown's address. I have his PIN. So I know that he is presenting authentically in this user case. On that basis, I am going to pull George Brown's information and proceed to whatever is the transaction in which he wishes to engage. Only the user in the institution that has access to that administrative data can access that information. All your card does in that environment is makes them sure, beyond a shadow of a doubt, that it is you. Sir, as I close, the member for Christchurch Essential will appreciate this. There is an individual with my exact name in the Ministry of Finance. My exact name. In the Ministry of Finance, ironically, a ministry in which I worked for many years. Barbados is so small. She and I have the same service provider in a range of areas. You know how I know that? Because I show up, and the person behind the desk, to their credit, asked me to verify my address because they have two of us. And I tell them, but here's the rub. I know the young lady's address, so I could have given them hers. When I use my card and I put it into their system and I put in my PIN, it could only be me, sir. And they're not requiring depending on my say-so. That is the information that they see, that is secured. Sir, I am not surprised that there is an environment of, I won't say mistrust, but perhaps, given the global reality, that people want evidence of security. The digital ID, the steps we are taking with respect to cybersecurity, these are all for the purpose of protecting the consumer and making it easier to carry out business day by day. Ask the staff of the Electoral and Boundaries Commission how many forged old ID cards they have come into contact with. How many replicated, how a person with a laminator and a piece of blue paper can type on a card and scribble something on it and say, this is so-and-so's ID card. That technology, if I could call it that loosely, was more susceptible to forgery than this current technology. And I'm not saying that we do not have a responsibility to prove our cybersecurity capacity. Absolutely we do, and we will. But the whole point, sir, both of the legislation and of the ID card and associated functionality is to secure the consumer. I just want, before I take my seat, to respond to the notion that, and I will say to the producers of this document, the team and I will talk with you. We will talk to the country. We only have an interest in strengthening security, not in convincing people that we are secure when we are not, because that will soon come to light. The notion that there was, in December, a leak of the preliminary voters list in December 2021. The individuals consider that in December 2021, a list of Barbadians with our names, national registration number, gender, date of birth, residential status, constituency, polling station, and address was exposed to the open web. That's the categorization. And that even though it was since removed, the document could be downloaded by anyone with access to the internet, has been shared multiple times, and so on. Sir, The register of electors is a matter of public record. This information is available to the public. Sir, the fact is that your national registration number, unlike identifiers in other jurisdictions, your national registration number does not in itself give you access to any goods or services or benefits that can be stolen once a person is in possession of the number, just knowing that number. So I can't show up and say my ID number is so-and-so, and so I want the pension check for the member for Christ Church Essential. Right? There are other credentials that have to exist at the same time that you have to present with. Now, I understand, and the data commissioner will be the first to tell you that there is a different level of accessibility when something is in an online environment as opposed to when I have to go physically to a place and look for it. The fact of its publication is the same. So the voters list is published. Preliminary lists are published as the register of electors is updated, and then closer to when a general election is called, a final list is published. It's a matter of public record. Anybody can have it and keep it year after year after year. Now, where I understand people's surprise, perhaps, was that that may have been the first time that it was published online. There's a conversation to be had about differences in accessibility, but certainly whether it is online or physical, the fact of it being available online does not give a holder of the document any more power to engage in unlawful activity using your information than they previously had for all the decades that the list was being published. We must, as a country, come to a common understanding of what information should be in the public domain. Sir, we have CCTV cameras all over, here in other jurisdictions. In another place in which I lived, the fact of CC cameras alone, their presence, meant that you could essentially trace my movements for a 24-hour period. Where I lived at that time, the residents had advocated aggressively for more cameras because they had had instances where the authorities were not able to investigate and prosecute crimes because they did not have the evidence that would have allowed them to do so. There were no cameras in place and so on. We have, as a country, to agree on what are the acceptable risks, and I say acceptable because what is the real risk to you of an address being known publicly that is right now in the directory? The group considers that the publication of the list online made them susceptible to stalking, breaking and entering. How so as against a telephone directory? How so as against going to the Electoral and Boundaries Commission and getting a copy of the list? So, sir, as I sit My desire is not to trivialize or dismiss any concern of any individual. I think that it is our collective responsibility to, one, demonstrate security and confidence from the government and from the private sector, because the government doesn't run commercial banks in this country, which probably represent the greatest capacity for financial risk and loss. And I noticed that the credit unions, the banks, are, as we speak, beefing up their cybersecurity capacity, as must government. But we need to collectively determine, if we want the benefits that we say we want, what does that mean for the information that we share about ourselves? Given that we have an expectation that those who administer the information are doing so with the utmost security and safety in mind. And also that each individual has a responsibility to act in a way that keeps them safe. That cannot be understated. And so, if you see a link from a person that looks, there's sometimes I get a message, the link looks strange. And I will call the person or message the person and say, did you send me this and what is this? Because I'm not clicking on it. There are friends of mine who know, warn me first, because I'm not clicking on anything that you send me. New AI technology. And we must move to the place where we adopt and understand technology. But new AI technology will mean that, remember, for St. James South, I see her calling me and I answer. And I say hello and it is her voice. And she says to me, come quick. My car stalled in some water here at Boston University Hill, come quick. Except that is not the member for St. James South. It is an AI-generated voice made to call from her number so that I can act in a way that might put myself at risk, that may mean financial gain for the individual calling. These are all things that we have to deal with. And a lot of the guidance now is saying, if that happens to you, especially if it is a call for a ransom, somebody says they've been kidnapped, somebody says they're in some kind of suspicious circumstance, hang up, call them back, perhaps on a different number. Regrettably, these are things that are affecting us today. And we do not want to be paranoid, but we have to be careful. So, sir, I have to emphasize that issues related to cybersecurity threats, defense strategies and methods are also matters of national security. So while we agree to come and have this conversation, these issues will continue to be the subject of discussions with the National Security Council. We as a government will go as far as possible in sharing with citizens enough information to create confidence and improve education so Barbadians also protect themselves, but we cannot disclose everything. We will not announce to the world any specific vulnerabilities that we are addressing or any gaps in our coverage that we are working to close, because that in itself is a cybersecurity risk. You don't win a battle by drawing a target on your chest and showing your enemy where to hit you. And in all matters of national security, that has been and must continue to be our approach. So we will go as far as we can in discussing the strategy, but we cannot declare all. Sir, I want to give my thanks of the Cabinet to the Law Reform Commission that continues to do tremendous work and has done human service in bringing this bill to where the point of consideration before us today. Again, I must thank the ministers, the members for St. Michael West and St. Philip West and St. Michael North. This bill benefited from both their stewardship, and it has been a lot of work. And so, again, I thank them for their contribution to this, another important transformation. All the stakeholders who participated in these consultations, both within and outside government, the officials from the Council of Europe, who continued to give support to the Minister, to the Attorney General, to the Law Reform Commission. Mr. Speaker, I have to especially thank the Attorney General, who, by virtue not just of his office, but of his inclination, was a senior minister to many of us, and generosity of spirit, of course, and modesty. But with those inclinations, sir, has been a senior minister to many of us long before that title was created. And I have to say, sir, that he embodies the practice of being at once a peer and an advisor, of guiding in partnership rather than hierarchy, and I consider it a worthwhile lesson in approach. Sir, with those thanks, I commend this bill to this honorable place, and I beg that it be read a second time.